Hi there, I'm Jenna Leyton Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at some pending California legislation. The California legislature is considering several bills which, if enacted, would impact California's employers and employees. Existing civil rights provisions provide that all persons within the jurisdiction of this state have the right to be free from any violence or intimidation by threat of violence committed against their persons or property because of a political affiliation or on account of a position in a labor dispute, or sex, race, color, religion, ancestry, national origin, disability, or medical condition, or because another person perceives them to have one or more of those characteristics. Assembly Bill 2617 would prohibit a person from requiring a waiver of the protections afforded under those provisions as a condition of entering into a contract for the provision of goods or services. The bill's provisions would apply to contracts entered into or modified on and after January 1, 2015. This bill is currently pending in the Senate Judiciary Committee. Senate Bill 404 would create a new protected class under California's Fair Employment and Housing Act. The new class would protect any individual or anyone who is perceived to be or is associated with an individual who provides medical or supervisory care to a listed family member, including a child, parent, spouse, sibling, grandparent, or grandchild. This bill is in the Assembly Appropriations Committee. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. In White v. County of Los Angeles, the California Court of Appeal analyzed fitness for duty examinations. Plaintiff Susan White was an investigator for the Los Angeles County District Attorney. Before requesting a medical leave of absence, she made numerous errors and acted erratically over the course of several months. In 2011, White sought leave for mental health problems. White provided medical certification, and the DA's office approved her leave under the Federal Family and Medical Leave Act. After exhausting her FMLA leave, White's doctor certified that she could return to work in September 2011. In September, the DA's office reinstated White. However, she was assigned to paid leave at home because the DA's office was investigating White's pre-leave misconduct. The DA's office requested that White attend a fitness for duty examination before returning to her regular job duties. White refused, claiming that the FMLA required her to be reinstated based solely on her doctor's certification. White sought an injunction, which the trial court granted. The DA's office appealed. On appeal, White argued that requiring her to undergo a fitness for duty examination after reinstatement was tantamount to interference with her FMLA rights. The Court of Appeal disagreed, holding that the DA's office was justified under the Americans with Disabilities Act. Before White returned to work, the DA's office had to accept White's doctor's certification and return her to work. After she returned to work, the FMLA protections no longer applied, and the DA's office could require a fitness for duty examination consistent with the ADA, which requires the examination be job-related and consistent with business necessity. In this case, White had engaged in odd behavior in a job requiring good judgment to avoid serious injuries or death, and her employer's request for a fitness for duty examination was proper. Employers should be cautious about requiring fitness for duty examinations for current employees and should approach each situation on a case-by-case basis to determine whether such examination is job-related and necessary. In Thierry v. Lucky Chances, a California Court of Appeal held that the trial court lacked the authority to rule on the enforceability of the parties' arbitration agreement because the parties had delegated this authority to the arbitrator, and their delegation of this authority was valid. More than 3 years after she was hired as a cook, Lourdes Thierry signed an agreement with her employer, Lucky Chances, requiring disputes between them to be resolved by arbitration. In one of the provisions, the parties agreed to delegate questions about the enforceability of the agreement to the arbitrator instead of a court. Thierry was subsequently fired, and she filed a complaint in Superior Court for wrongful discharge. Lucky Chances petitioned to compel arbitration. The trial court denied the petition on the basis that the arbitration agreement was unconscionable and therefore unenforceable. Lucky Chances appealed the court's order denying arbitration. The Court of Appeal sought to determine whether the trial court properly denied Lucky Chance's petition to compel arbitration in light of the delegation clause. The answer turned on whether the delegation clause was valid under state law unconscionability principles. The appellate court examined the language of the delegation clause and determined that it was clear and unmistakable. The clause stated unambiguously that the arbitrator, and not any federal, state, or local court or agency, shall have the authority to resolve any dispute relating to the interpretation, applicability, enforceability, or formation of the agreement. Next, the court analyzed the delegation clause on state law unconscionability principles and determined that it was valid. Although the court found that the delegation clause was procedurally unconscionable because it was a contract of adhesion and was presented on a take-it-or-leave-it basis, the court nonetheless determined that the clause was valid because it was not substantively unconscionable. An arbitration agreement imposed in an adhesive context lacks basic fairness and mutuality if it requires one party, but not the other, to arbitrate all claims arising out of the same transaction or occurrence. The court determined that the delegation clause here did not lack mutuality because Thierry and Lucky Chances were bound by it equally. Therefore, because the delegation clause was not overly harsh and did not sanction one-sided results, it was not substantively unconscionable. Having determined that the delegation clause was valid, the appellate court concluded that the trial court's denial of Lucky Chance's petition to compel arbitration was improper. The Court of Appeal ruled that the arbitrator must consider the conscionability of the arbitration agreement as a whole and any of its other severable provisions. This case confirms that parties to an arbitration agreement may provide in the agreement that if the arbitrator has the sole authority to determine the validity of the arbitration agreement. Finally, in Rosenfeld v. Abraham Joshua Herschel Day School, a California Court of Appeal examined the disparate impact theory of discrimination and the avoidable consequences doctrine. Ruth Rosenfeld resigned from her teaching position at Abraham Joshua Herschel Day School in 2007, citing an intolerable work environment. Herschel had reduced Rosenfeld's teaching hours from 25 to 10 hours per week over a 3-year period. Rosenfeld attributed this solely to age discrimination. Herschel defended its decision to reduce her hours on the grounds that its enrollment had dropped from 455 to 391 students. Rosenfeld filed a lawsuit in 2008 alleging age discrimination under a disparate treatment theory. She later attempted to add a disparate impact theory, but the trial court rejected this claim on the ground that Rosenfeld did not assert it in her initial pleading. At trial, Herschel prevailed on the basis that its reduction of Rosenfeld's hours was valid and her at-will status did not guarantee a specific number of hours. Rosenfeld appealed the ruling on the ground that she should have been allowed to pursue her claim of discrimination under both disparate impact and disparate treatment theories. Rosenfeld also asserted that the trial court improperly admitted evidence that Rosenfeld failed to exhaust Herschel's internal grievance procedure. The Second Appellate District upheld the verdict in favor of Herschel. In its ruling, the court explained the clear distinction between discrimination that is direct and unintentional, also known as disparate treatment, and conduct that unintentionally leads to a discriminatory result, also known as disparate impact. Because these claims turn on distinguishable facts, they must both be pled explicitly to allow the defendant a reasonable opportunity to prepare a defense. Rosenfeld did not plead both theories, and as such, she was limited to pursuing a disparate treatment theory. The court also held that Herschel had validly asserted the avoidable consequences doctrine as a defense to damages. Under this theory, Herschel could avoid liability for any damages that likely could have been prevented by Rosenfeld's reasonable utilization of Herschel's internal grievance process. Rosenfeld's decision to resign, rather than file an internal grievance, prevented her from having her hours reinstated, which the court determined would have happened. Notably, the court recognized that if Herschel's internal grievance process was ineffective, or Rosenfeld's failure to use it was reasonable, the defense would have been unavailable to Herschel. This case highlights the benefits of an effective internal grievance process. Such a program not only fosters better relationships between staff and management, but it can provide a strong defense for employers against damages should claims arise. Because the impact of this defense turns on the quality of the grievance and investigation process, employers must consistently review their programs. The cases I just mentioned are a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please email me at jleyton@petitcone.com. That's all for this quarter's legal update. Thanks for tuning in.